Two, two, two. Check. This is Mr. Perry's room. Document audit part 2. We're gonna dive into some more documents, expand on this timeline a little bit more. Again, better resolution, higher resolution documents and images can be found. Twitter, Instagram handle _JASONPERRY_. Also, there's I was able to place part 1 on YouTube. There's a YouTube channel. Well, as videos begin to accumulate, it'll pretty much be presented as a channel. Just gonna dive right back into it. I'm probably gonna get into, I was thinking of getting some updated documents, but I'm probably gonna lean more towards kind of digging down the rabbit hole. But another image that I see in passing quite often, that similar to one of our other images. I think we're on about image 8 or so. But this is, I'm going to make some amendments and addendums to the timeline from 2011. Sorry about that. And the glare. This is little pause. So I was going to amend the timeline a bit, but the kind of the time frame, the range that was given on part 1 placed us at about 2011. But I do recall this because it was kind of a pre-K program. Basically, before he wasn't in kindergarten yet. I believe he began, actually, that's what we'll probably dive into Orange Park Performing Arts Academy, first grade, in that kindergarten transition. But La Petite Academy would be 2010, and I'll go ahead and document image 8, this one. And again, better resolution on Twitter and Instagram. But this is the face that I was speaking of. I think I still have that shirt that would run down the hallway when I came to pick him up. Too much glare? No, decent. When I came to pick him up from a Little Pause. It was always again, some of the better times. Some of the good times. So he was a little older than this. Yeah, so that this account of domestic violence that I survived occurred around 2013 or so. 2012, or actually, 2013 or so. So let's get into some documents. I think the documents will probably add up, put a little more reference to populating the timeline. And I also want to add 2008, mention Roosevelt Gardens, where he stayed at first, then Downing Street. But also 2009 is an interesting timeline to place as well, because in 2009, that's when the Department of Revenue became involved. And that was an interesting situation. Myself and the opposing party in the basically what's commonly known as the child support case, we both went to and this is the naivety of being involved in the court systems. We both went to I believe it was the Department of Revenue's office in Green Coast Springs, because it was a Clay County case, and I believe that's where that main office is located. Very inconveniently placed, being that we had traveled. Um, he was born in Jacksonville, but this is what occurred when he was first removed from our custody. Um, he was taken to Clay County, and kind of the step and fetch, because you just want to be a father and you don't want any drama, any tension. You just accommodate yourself and you say, I'll drive to wherever I need to drive to continue fathering my son. I'll probably actually maybe dedicate an entire part to the whole Department of Revenue and all the nuances of that. And actually some of these documents may again on the timeline may pop up. Let's see, I haven't dove into this in quite some time. And we'll start with the top. So this first folder, actually this will be an interesting little deep dive to take as well. This is Alex's, one of his folders, and I can kind of dive into a bit of the conversation that Robert Elrod had with me the other day in requesting the documents, my son's school documents, and basically when he was enrolled without my knowledge into Otis Mason Elementary School in St. Johns County. He was withdrawn from Orange Park Performing Arts Academy without my knowledge on the day that I was teaching at Robert E. Lee. It was actually, I think it might have been in between basketball practice or some type of extracurricular activity that afternoon. And I went, I believe that was the Tuesday prior, I had picked him up from Orange Park Performing Arts Academy. Same old spiel, brought him home. When we did activities like what I'm about to share with you in a moment, and I dropped him back off at school at Orange Park in the morning. This was, I believe, the year after Pop Warner. So this was about, this is almost about 2015. We'll get to kind of 2016-ish. But that Thursday of that same week, he was withdrawn on that Wednesday after I took him to school. He was withdrawn that Wednesday, and he was enrolled in St. Johns County on that Thursday. We requested those documents. I believe Nigel Pillay, the principal at Otis Mason Elementary School, stated that some sort of waiver had been signed so that a Clay County child could attend a St. Johns County school, and that allowed for my son's enrollment, Alexander's enrollment, without my knowledge, and actually in contempt of the court order entered in Clay County, stating that and this is the reason why his school had become that, even though there were several discussions back in the Duval times, but I guess me being unaware of someone else's intentions, that's how he ended up in Clay County. Several court cases entered into the system through Clay County's court, clerk of court. But I want to step into this because, again, from that school, taken to St. Johns County, and then the child's address by court order supposedly being the Clay County address or Clay County school, would kind of be a conflict of interest. And I'll also speak to Reginald Estelle's inability and inadequacy to argue this point, or actually to bring this point to the attention of a judicial officer. Namely, I believe Michael shared at the time. But I also wanted to mention that the document one that was viewed on part one, that's also available in better resolution at the social media handles. It has been filed. Now, before I dive into this, let me get this off. Miscellaneous document. If an attorney doesn't file something, typically correspondences, like the several things that you'll also see as documents, get filed as miscellaneous. And I want to MISC that. And I'm going to kind of dive into that definition and whatnot a little bit, maybe on that Department of Revenue episode. But Alexander had made a collage representing the 4 seasons. I mean, yes, winter was the season that he had. And what happened is he had a science book that I had got with some information, just some random things. And he would always want to have me quiz him. Because pretty much, again, being a teacher from 2008 up until my untimely dismissal, which we'll probably have to get a whole part 2, Alexander he pretty much always wanted to be a student. It's like he would want to fit in, or, the social dynamics of being a young child, going to work with your parent, and kind of wanting to do, whatever's commonly the behaviors and mannerisms. Alexander has spent quite a few times in quite a few classes of mine. There was even one summer where I taught summer school, unfortunately, in an effort to maintain the court-ordered child support payments, teach summer school, but not having the funds coming through child support to cover child care. Alexander wasn't put in child care. He would come to work with me. And I believe, who was the assistant principal at that time? Her name escapes me, but when we get into that, more of my teaching profession, it'll probably come back. But I believe she mentioned to me that it was an issue, and I think I kind of finagled it, may do. But this is kind of recent. I would just, when I was a in-school suspension instructor, Alexander would come to my classrooms after his grandmother would have to travel to another city to pick him up. We'll dig into that a little bit later. And I would just write little questions, and he would just provide answers. I'd give him pretty much the time it took for me to grade papers or prepare my room for the following day. What are 3 ways matter can change from one to the other? Solid, melting, liquid, freezing, evaporate. Man, this kid was pretty good. Of course, and actually I would give him the page number so that he could reference it, but it's similar to, again, what I would do with the students who at the time were assigned to in-school suspension. I gave him a dung beetle project. I kind of tried to give him all subjects. The scarab and the dung beetle. Kind of wrote some things down. Again, better resolution, so I'll save kind of going through reading all those. We're approaching the 15-minute mark. I might take this one about 1 hour and 15. Let's see if we can push the limits. We'll call these the set will be image 8, or image 9. Notate there are multiple there. Set that to the side to demonstrate. I didn't mention that conversation. Again, seeking those documents that would prove in a litigation that a contemptuous action had occurred, compelling a judicial officer to make a judgment in favor of one party or the other. I was asking that these documents be acquired, and pretty much I posed a question to Robert L. Roth, what he planned to do with them, how he intended to use them, how he intended to argue them. Amongst these documents, he prefaced in saying that he had a gathering of documents and that he said, well, Alexander's grades are good, as if to temper my anxiety or temper my, pretty much his absence and the disconnection of fatherhood that a child deserves and should have the right to. Disenfranchise is a key word that kind of pops up. But it was almost as if him mentioning that my son's grades were well was in some way designed to calm me down or distract me, I should say. I'm gonna find a way to play this. I actually have some video that we're gonna dive into momentarily. All right, this is a pretty big one. I might have to dive into this, I suppose. I made contact with the victim, who stated her ex-boyfriend and father of their son came to the school to pick up the child. Okay, we'll come here. So the violation of injunction. When I picked up my son from school, Mitchell Watson is the one who took this narrative down. Oh, okay. Yeah, we may have to, I suppose we'll have to dive in here. I received a call from my employer informing me that my son's father was at my place of employment attempting to check our son out and causing a scene in the presence of the staff and our son. He became belligerent and argumentative with my principal. He called him a liar and demanded the emergency contact card so that he could amend it. Demanded is such an interesting word. The verbiage used. I actually want to dive a little bit deeper to the past before I come here. And I actually may touch on this injunction while I'm here. Sorry for the pauses. I'm deliberating. I'm having I'm having anxiety attacks right now reading this. Oh man, yeah, I've got quite a bit here. But I want to talk about this word used in one of these affidavits, belligerent, because the police department uses this phrase as well when they fill out their police reports. And I believe the opposing party uses this phrase because of her past experience working as a child protective investigator or child service investigator around maybe 2000 and maybe I'd say 2010, maybe, because at the time that the child support case was entered, there was no employment filed for the opposing party. So child support had been calculated based off one income up until actually it was petitioned to be amended, and then the system has its ways of even blocking that if you can't, of course, economics of freedom afford appropriate and adequate representation. But this word belligerent, and I wonder how you can describe someone being belligerent through a phone conversation. Causing a scene and belligerent are phrases that are constantly used to describe my physical presence. And I'll even state that at one time, causing a scene was written down in an affidavit or a document or a police report referring to a time, or actually a date, when I went to the Department of Revenue's offices. Actually, I'm sorry, the Department of Children and Families offices downtown Jacksonville. I believe it's on Davis Street. And I went to inquire about filing a child abuse report, but I was curious about the conflict of interest because the individual committing the child abuse was an employee of the Department of Children and Families or Children and Family Services. Went to speak with supervisors or higher up people in the hierarchy of that particular establishment, and it was stating to be causing a scene. Never testified to, no specifics, just the phrase, causing a scene. I want to touch on this. I think there's an injunction in here, and I actually want to touch on this because there's two injunctions. If you actually, on Instagram, you'll see there's an injunction filed in 2015 that a Duval County judge denied. And that's will probably get its own part as well. But I do want to touch on this. This cause came before the court on May 18th, 2016, a very important day. Because on this day, no testimony was allowed to be given regarding the domestic violence that has occurred in front of my son. No testimony actually from any family member. Active, I would say, in my son's upbringing. Was actually given, requested from the judge or attorneys present. Father being present together with counsel and the mother being present pro se, the court finds that it is in the interests of their minor child that the father have unsupervised time sharing. There is competent and substantial evidence of unwarranted harassment, and a continuing injunction as to the mother is necessary. Part B is the interesting part, because the substantial evidence was actually several emails, and I may have to dig for those emails because I definitely want to drive into those. It is in the best, we covered that. The parties agree that the father may have majority time share the entire month of June 2016. Let's see, shall have no contact with the place of employment. The father shall not attempt to contact the other party. And let me see where it says about picking the child up from school. Yep. So this is what I believe my Robert Elrod attempted to explain to me, was describing me not being able to pick up my son from school, which is I'm still looking to see here. Now, again, you'll be able to read for yourselves and see where it specifically states that. Says weekend time sharing, and this is what it is: after school or summer camp. The weekend time sharing notated in this particular order only referenced summer time sharing. Says that for purposes of picking the child up from school, facilitating, exchanging, the maternal guardian act as an authorized surrogate. In the absence of agreement, the exchanging party shall be limited to the father. Okay. At a substation. A period of time. And actually this says it was done in order on June 1st. But the actual hearing took place on May 18th. So this is kind of interesting. Yeah, what I want to do is go ahead and get a picture of this, an image of this. And I'm going to let you all read through this and see for yourselves what occurred, or what this kind of reading between the lines here. Because this is an interesting document. It's very vague, as law enforcement officials have continually told me throughout, probably since 2014 or so. But that concept will come up again. Clarity, definity, and the exhaustiveness of court orders regarding parenting plans and family law matters, just a jewel. They should be extensive. It should be to the T. And that's kind of the ordeal when you can only afford an attorney who's only going to give you an hour in a hearing, where 45 minutes is one person lying and complaining and exaggerating and stretching and embellishing and defaming, and then reserving 15 minutes to say, well, we don't want to argue, we'll just settle for whatever we can get, is the strategy of those who do not prosper in the economics of freedom. But I want to add, this is document 2. We'll call this the injunction in question. All right. And I actually want to give, pardon that feedback, another phrase, some highlight here. Competent and substantial. what this actually means is not that anything was true or false when you think about it. It means that the individual who was stating the sentences, words, expressions that they were stating, the lies, they appeared competent to the judicial officer. And they gave enough substance. Basically, they were wordy, they were long, they gave they said a lot of stuff. And they didn't appear to be under the influence of, I suppose, drugs, or so to speak, or medication and things of that nature. I want to dig a little deeper, see what direction this takes us. Oh. There was actually an amended motion to increase child support. This is we got a few things here we might be able to dive into. Yeah, I'll kind of go through this packet, see if it can get us to the 45-minute mark. Throw some dates out. That is the result. Competent and substantial evidence was ruled in favor of one party. And this one will actually go back up. This is the document I was saying that you could see in the old Instagram feed, I believe it's there. This one says that the court has reviewed the ex parte petition, meaning no parties were present or no attorneys were in the room with the judge. It was just one person's account, one person's affidavit, so to speak. The court has reviewed the ex parte petition for injunction for protection against domestic violence with minor children filed in this cause. This is when I filed for my protection and my son's protection when I was attacked, and we're going to speak to how it was flipped and competent and substantially regurgitated to the appeasement of a judicial officer granting in favor of one party, a particular party. Although the petition may allege angry confrontations between the parties, the petitioner has failed to allege facts sufficient to support the entry of an injunction for protection against domestic violence, because the petitioner has not alleged any specific acts of domestic violence that has occurred recently, and the allegations of past acts of violence standing alone are not sufficient to show that petitioner is in imminent danger of becoming a victim of domestic violence. I want to speak about that petition because it was filed. However, only one copy was filed. So in my potential search for that document will probably be very unsuccessful, being that the clerical courts goes through so many filings a year. This also was filed. This was filed on June 2nd, but it was the petition had been filed probably prior to that, maybe a week. The turnaround time was pretty quick on this, I recall. This will put us actually on the timeline at 2015, same place, but this is June 2nd. Yeah. And I'm going to fill this in because we may have to stretch this out. But yeah, this is going to be a very important document because I want to spend some time in this document, or in this petition, is when I specifically stated my actual occurrence of what document 1, the witness to the attack, filed. Again, but what the witness stated was filed as a miscellaneous document. An injunction was filed on my behalf and it was denied. So this will be document 2. Slow start on the documents, quite a few images. Document 2. Well, actually, I believe I have a document 2 already. This is document 3. All right. Now I want to get into something. I see something typed, but I don't know if this was actually filed or not. Yeah, this was filed. I don't believe it has been heard. Okay. The father's verified emergency motion for contempt of court and enforcement. At the time of contempt hearing on July the 17th, 2015, the minor child was enrolled for school in Clay County, Florida at Orange Park Performing Arts Academy. The mother unilaterally, without discussing the issue first with the father as ordered in the parenting plan, withdrew the minor child from the school. Both orders state that the child will attend the school as determined by the mother's address. After unilaterally withdrawing the minor child, the mother enrolled the child in St. John's School District at Otis Mason Elementary School. The mother's actions were contemptuous, and the father requested the court hold the mother in contempt of court and order that the child be re-enrolled at the Performing Arts School in Clay County. Yeah, this was just a request. And I think I may close out. If I get kind of too long-winded, around 40 minutes, I may close out with what these requests and what these filings and kind of the posturing of attorneys is, the roles they serve. Let's see what else we have. Oh yeah, this one was juicy. This one was juicy. So this is one of the filings, one of the many filings that was filed and awaiting to be heard. Oh yeah, there's that withdrawal notice I spoke of. Alexander Perry withdrew from Orange Park Performing Arts Academy on August 26, 2015. This is how I was notified that my son's school was changed. Alexander was enrolled in St. Johns County on August the 27th, 2015. Alrighty. So where are we here? That time I was going to put us a little further there. But these are some important dates. So May 18th is here. And actually, I want to bring it down here, and I'll zoom out. There'll be a wide, kind of a widescreen picture that'll provide access to the entire chalkboard. But I have a extended timeline down here. We're gonna put August 26, 2015 down here. Kind of a real important date. And then August 27th. Those are two pretty big important dates there. Have some enrollment documents. Oh, and one of those interesting emails. Hello, Jason. I am unable to meet at 3 on Friday. Are you able to meet at 6? Or if you'd like, you can pick Alex up from camp. At camp, they are having a last day cookout starting at 1 p.m. Also, you previously mentioned that you all would be vacationing this coming weekend. Can you please send me the details of this if you all will be out of town, and what time are we meeting on Sunday evening? Interesting email, but as, again, law enforcement officers and representatives will tell you, anyone can have sent that email. To whom it may concern, or St. Johns County Clerk of Courts, this communication is concerning my grandson, Alex Perry, who has been a regular and routine part of our family life since birth. More recently, however, Alex has been residing at home for the past year. What I want to do with quite a few of these documents, because this is actually a package that I've sent to quite a few elected officials, as well as Clay County Courts, Clerk of Courts, St. Johns County Clerk of Courts, Duval County Clerk of Courts. Quite a few of these things have been filed as miscellaneous documents and will continue to be so until appropriate and adequate legal representation can litigate them appropriately. Yeah, I got quite a few correspondences here. Yeah, we don't want to just sit and read through these, but I want to see if anything in particular pops out here. There was also another motion to rehear the case, which was pretty pointless, as most attorneys have told me after the fact. in an attempt of requesting a rehearing. It was quickly denied upon consideration. Very brief, very brief writing there, but quickly denied. Let me see if I have anything here, because there's a particular filing that I'm looking for. Yeah, I may have to dig a little deeper because I wanna address the competent and substantial filings. I think what's going to end up happening with quite a bit of this, it'll just be accessible through Instagram and Twitter. I'll do my best to, what do they say, redact addresses for privacy and things of that nature. But yeah, quite a bit of this. Oh, Mr. Thompson. We'll kind of end on this notice. We'll end on this note. Yeah, this will be a good segue to, because I have quite a bit to go through here with all these numbers and such that I'm staring at. I can also dive in part two. Well, part three. I'm sorry. What we're going to do, we're going to dive into the actual parenting plan, child support court order, and yeah, my employment as a teacher, my career as an educator, because that'll kind of take from about 2008, 2009 to about 2015. That we'll kind of finalize that in part three, and it'll be more of a narrative. Probably provide a couple more pictures and things of that nature. But the termination of employment as an educator, that'll kind of be the bridge over into the more current court proceedings. But what I do want to mention is an interesting individual, Mr. David Thompson, whose response to me stating that I had been pretty much attacked and assaulted and things of that nature. Basically the same pleading that I had made in the petition for my protection, which on June 2nd, 2015 was dismissed. I pretty much recounted the exact statements, the exact accounts, the exact testimony to Mr. David Thompson. And his reply as a judicial officer, I believe he's a retired judge, a former judge, in a mediation, he said to me, "What, you can't take a punch?" So that spoke volumes as to the attitude, the position held by just the mediators. And the mediators are a far cry from, they give you the spiel about, they're not a judge, but if anything happens that is agreed in their presence, they can take it to a judge, and the judge will be more likely, more prompt, more amped to just follow up and sign off on the order, whatnot. But that particular phrase, can't take a punch. Thompson. And they don't have the date of the actual mediation, but there is a date of, I suppose this is the date of the mediation, which was actually, I'll step into kind of the nuance of how this mediation outcome was filed incorrectly, being that it stated that I did not pay, but there was a no mediation fee assessed, but it's not reflected in what this filing says. So this filing would go before a court or another judicial officer, and they would actually see the language that the respondent has not paid, with the clerical error being that the respondent had paid. It would be overlooked that the actual party was in compliance of some sort, even to the tiniest degree, because compliance Upper with belligerent. Compliance kind of come over here. That's a buzzword. To appear in compliance would be beneficial at all times, and to have something as simple as a mediation outcome with a mediator making such statements and inaccurately filing a document, it's not necessarily paranoia, but it is the wind to a flame that may have already been kindled of anxiety, animosity about how the system portrays in particular parties who are representative or members of particular people groups. This was March 21st. Most recent mediation, there's actually 3 mediations have taken place already. And another mediation, the most recent one, I believe December of 2017, another mediation took place. 2 in 1 year. Interesting. But mockery was made of my family's attempt to continue raising and contributing to Alexander's life. Just very distasteful comments were made. But again, it wasn't too dissimilar from any of my past experiences, which interestingly enough have kind of lined up to show that my status in the economics of freedom is pretty low, pretty poor. It's pretty much existing in a state of poverty when it comes to freedom or rights, so to speak. The phrase I was just about to belt out is nothing new, but it shouldn't be. And I kind of want to clean the board afresh for part 3 and kind of stick with just one thing. This is an interesting kind of timeline to kind of dive into. It opens some things up. Does open some things up, but I want to dive into some particular spots. Again, part 3, I'm going to focus more on particularly the Department of Revenue case that got opened up. My profession as an educator, kind of that range of experiences with Alexander, and kind of how he's coming to his own as just a natural student, a great-minded young man. And I also stated that we'll kind of get more into the actual first petition, because those are the initial 2 documents that kind of everything else hinges on. Those are the initial documents that kind of started this interesting ride here of chasing enfranchisement, so to speak. Mr. Perry's Room, part 2. I do think I foresee maybe 10. It may take 10 parts to kind of unpack quite a bit, but I don't know. We'll see. The next part, I may try and push the 1 hour mark. But for now, I want to get these documents together, kind of redact some things. High resolution images will be available at the Twitter feed and the Instagram feed. Feel free to comment on in messages or in comments of the images, or on the if part 2 gets added on to the YouTube platform. There'll be comments available there. You can reach out if you have any questions, if you have any suggestions, if you have any help, assistance, if you know any good lawyers. That's I don't want to say not commercial, so to speak, because I've actually take a deep dive into one of these legal guides I got, or magazines that have kind of a legal directory, and I may kind of give a little feedback to whoever viewers or listeners to the Mr. Perry's Room document audit, kind of point you in the right direction, kind of give rating, so to speak. But we'll stick to unpacking most of this. Document Audit's getting ready to see if the disenfranchisement ceases, and see if we can bring Alex on.